Today, we're going to discuss the different roles of local, state, and federal governing bodies and how these bodies pass laws. We will also discuss how laws in general are passed at the federal, state, and local levels, and we'll review guidelines on how to draft solid public health policies based on the best practices in the field. Although the webinar will use examples from tobacco control and in Minnesota, the session will be of interest to all in the public health world nationwide. This webinar is meant to be a refresher of those civic lessons you may or may not have learned in school, as well as an intellectual analysis of law and policy from experienced public health professionals. My name is Natasha Phelps. I am the moderator today and a staff attorney with the Tobacco Control Legal Consortium at the Public Health Law Center. I'm on the far left of your screen. As a staff attorney at the consortium, I provide legal technical assistance on tobacco control issues to public health professionals and organizations and advocates in Minnesota and throughout the United States. I'll go over what technical assistance means in just a moment. I also currently work as an adjunct law professor at the Mitchell-Hamlin School of Law. Prior to joining the consortium, I worked as a litigator defending clients against civil lawsuits. Presenting with me is my coworker, Mike Freiberg, senior staff attorney with the consortium. He's in the center photo on your screen. Like me, Mike provides legal technical assistance to jurisdictions around the country working on various tobacco control policies. Mike has worked as an adjunct law professor at the Mitchell-Hamlin School of Law, having taught classes in legislation and public health law. Mike also serves as a Minnesota state representative and spent 9 years on the Golden Valley City Council. From 1999 to 2001, Mike worked for a member of Congress as a legislative assistant specializing in healthcare. Also joining us today to provide some practical insight is Molly Moilanen. Molly has served as a director of public affairs for ClearWay, Minnesota since 2011. Before that, she served ClearWay as senior program manager for approximately 7 years. She has also worked as a program officer with Serve Minnesota and a legislative assistant with the Minnesota State Senate. We feel very lucky that Molly is able to share her insights with us today. We are providing this webinar from the Public Health Law Center, housed at the Mitchell-Hamlin School of Law in St. Paul, Minnesota, pictured here on the screen. The Public Health Law Center is a national nonprofit that works with community leaders, health advocates, and the general public to use law and policy to improve public health and address public health issues. We have 2 groups of attorneys. One group working on tobacco control policy, also known as the Tobacco Control Legal Consortium, and one group working on healthy eating, active living policy, also known as the HEAL group. The Public Health Law Center provides legal technical assistance. This means that we conduct and analyze legal research, provide support for policy development, implementation, and defense, create publications that are available on our website, and conduct trainings like this webinar that you are all a part of today. We do not, however, directly represent any person or entity. We do not provide legal advice. We also don't lobby or ask policymakers to take any specific action. The information that we're providing here today is for educational purposes only and should not be considered a replacement for legal advice. Based on our experience with public health policy, we are able to provide you with information for your own evaluation of these issues. So let's talk about what we'll go over today. I'll start us off with a high-level overview of government powers. After that, I'll carry the discussion into the concept of preemption and issues that arise when higher-level governments impact the activity of lower-level governments. Mike will then provide an overview of local-level government, how these governments have evolved, what power they have, and how they function. Mike will then dissect law and policy, what it is and how it is made. Following Mike will be Molly. Molly will give insider tips on practical policy considerations, strategic planning, coalition building, issue framing, and precautions from an advocate position. Her presentation will provide valuable insight as to how advocates can use this information in their daily work. We'll then conclude with a Q&A dialogue that I'll moderate. Please type your questions into the question and answer box, and we'll answer as many questions as we can get to at the end of today's presentation. As we go through our presentation today, and in your public health work generally, we hope that you will look or listen with an equity lens or filter. Good public health can simply not be achieved without addressing equity. Equity is achieved when we cannot predict outcomes by race or ethnicity or other demographic identity factors. For example, equity will exist in high school graduation rates when we cannot predict that any given group has a better chance for this achievement than any other. Health equity is achieving a high standard of health for everyone in the community, while at the same time concentrating on populations within that community that are at a disproportionate risk for poor health because of their social determinants of health. Social determinants of health are the circumstances in which people are born, grow up, live, work, and age, and the systems put in place to deal with illness. These circumstances are in turn shaped by a wider set of forces: economics, social policies, and politics. When we address these equity issues, we are able to achieve equality. As lawyers at the Public Health Law Center, the role we play as national partners is to analyze the legal viability of policy options. Our tobacco control and healthy eating active living work should address healthy disparities because we know that these issues affect underserved populations disproportionately. And because there are nuances when selecting, implementing, and enforcing a policy, the communities impacted most need to be truly engaged partners in policy work. Questions should be asked in order to ensure that the policy will result in public health improvement in all communities. And there should be a conversation about potential unintended consequences to policy options, like penalties and enforcement. Lastly, as we're talking about government powers today, consider accessibility issues within certain communities. In summary, when we talk about public health, we talk about equity. That being said, I'll now go on to provide a brief overview of government powers. People think each level of government has defined roles. For example, they might think that cities run the police department and counties handle human services like child protection. Some people assume that governments are the same in every state and that the federal government has a clear-cut separation of power and responsibility. The reality is that it's a lot more complicated, like a spider web. Cities often do have police departments, but there might also be a county sheriff. Other levels of government may also have police forces. Counties generally do handle human services, but other levels of government may get involved with this as well. Sometimes representatives of federal branches of government argue that the other branches have overstepped their authority. Government in the United States is a complex web that we hope to navigate with you at a high level today. A jurisdiction, to have jurisdiction. What do those terms mean? Generally, it means the power to govern or to make legal decisions. It refers to the legal authority of a government or a branch of government. A government may have jurisdiction over an issue or a territory. When we talk about the different levels of government, we can generally categorize them as federal, state, local, and tribal governments. Each of these jurisdictions have different levels of power to govern. They have their own structures and branches of government. The primary distinctions between the areas of government are codified at a national level as part of the US Constitution. I'll get into that language in just a few minutes. Going from left to right, let's start with tribal jurisdictions. Jurisdictions governed by tribal law are referred to in many states as Indian country. Indian country is legally established by congressional action, treaty provisions, or executive action. These tribal lands can include reservations. Whether or not an area is considered tribal land will determine if the tribe, the state, or the federal government has jurisdiction for different purposes. Generally, within these areas, tribal sovereignty applies and state power is limited. Moving on, the federal government is considered the highest level of government. You'll hear why that's important to understand in a moment. The federal government is broken up into different branches, which I'll go over on my next slide. State governments are created and governed according to their state constitution. Most states also use a similar model to the federal system. These governments have legislative, executive, and judicial branches. Different states do not have jurisdictional power over another. State powers give power to local governments within their states, allowing local municipalities to handle matters that are uniquely local, like zoning issues or local parking regulations. State governments are considered a lower level of government than the federal government, but higher than local governments. Local governments may be created and governed by a city or county charter. Mike will go over local governments later in the webinar. As you can see, jurisdiction can mean a lot of different things. And for that reason, if you have questions about various types of jurisdiction that might apply to the policy that you're working on, please feel free to contact the Public Health Law Center concerning the laws related to your particular question. What's important to remember during this presentation is that there's a hierarchy of governments in this country. Federal at the highest, then state, then local. This separation of power and hierarchy was created at the federal level, so let's talk about the highest level of government, the federal government. The United States Constitution created the federal government, or the government of the entire country, and separated it into three branches: the legislative, executive, and judicial. All branches are meant to check and balance each other so that no branch has more power than the other. The idea being that these checks and balances will help to prevent a dictatorship or autocracy. In order for this to work, each branch of government must actually check the power of the other. The legislative branch, which may make you think of Congress, essentially creates laws and allocates resources. They are voted into power by the people. The president can veto these laws, and the judicial branch can rule them to be unconstitutional. The executive branch, through federal agencies, has the responsibility for the administration and enforcement of federal laws. The responsibilities of federal agencies vary widely, from environmental protection to ensuring the safety of human and veterinary food, drugs, and medical devices. The president can also declare executive orders, which carry the force of the law. While I mentioned that the president can veto a law proposed by the legislative branch, the legislative branch can override that veto with enough votes. The legislative branch also has the power to approve presidential nominations, control the budget, and impeach the president and remove them from office. The judicial branch can rule the president's executive orders unconstitutional. The judicial branch interprets laws. When we talk about the federal judicial branch, we are talking about the Supreme Court, the Federal Court of Appeals, and federal district courts. Generally, federal courts have jurisdiction when a federal question is presented or when there's diversity of citizenship among the parties. Otherwise, state or local courts have jurisdiction over many legal matters. Again, jurisdiction is a complex issue. Supreme Court justices, Court of Appeal judges, and federal district court judges are nominated by the president. The Senate in the legislative branch confirms the president's nominations for judicial positions, and Congress can impeach any of those judges and remove them from office. In the 18th century, the United States was supposed to be a loose confederation of separate states. Over time, Americans and the rest of the world has identified it as one nation. The framers of the Constitution set aside certain rights and obligations that at any time they felt should be handled by state governments, while others needed to be handled by the federal government. This idea of federal versus state power has fluctuated over time, but the general boundaries between jurisdictions remain usually the same depending on whether something is of national importance, like interstate commerce, or of local concerns, like setting local speed limits. The concept of federalism is the allocation of power between the federal and state government. The federal government has powers limited to the Constitution, and the Supremacy Clause makes federal law the supreme law of the land. This is why I mentioned that the federal government is the highest level of government in the United States. Federal laws and regulations override or preempt conflicting state law or any law passed by a lower level government. However, the 10th Amendment explicitly reserves states' sovereign police power to regulate certain matters affecting the health, safety, and general welfare of the public. Public health is an issue that is generally thought to be best handled at a more local level. The separation of powers to the U.S. Constitution raises this issue of overriding a local government's authority. It is an important concept to understand in public health, how a higher level of government can limit the authority of lower level government. This brings us to the concept of preemption. Due to inaction and slow movement at the federal and even state level, more states and local governments are working to enact and strengthen important and sometimes progressive regulation. Local action is key to addressing the diverse needs of communities. When it comes to public health, federal or state law, one-size-fits-all law, does not necessarily work for every community. As state and local governments are fighting for their community's best interests by enacting these regulations, they are being blocked by federal and state laws that actually strip state and local governments' lawmaking authority. We refer to this as preemption. Preemption occurs when, by legislative or regulatory action, a higher level of government, like federal or state government, eliminates or reduces the authority of a lower level government, like a state or city or county government, over a given issue. The federal government has very broad authority to preempt. Under the Supremacy Clause of the United States, Congress and federal regulators have virtually unlimited authority, if they choose to exercise it, to preempt state and local health laws. Similarly, states always have broad authority to do the same. Occasionally, federal or state governments will set a minimum standard regulation in which state or local governments cannot fall under. These types of regulations do not, however, prevent local governments from creating standards beyond what is required by federal or state law in order to protect their community. There are different types of preemption. Express preemption is when a law contains a preemption clause or other explicit preemptive language. Here's an example from Florida. The language bolded here is expressly preemptive. It takes authority away from local governments. Note here that this preemption is also limited. There's an exemption for school districts. So the state of Florida has expressly preempted local regulation of smoking, with an exception for school districts. There's also implied preemption. Courts find law preempted even when it does not contain any express preemptive language. Occasionally, the courts will find that, given the context, the higher level of government intended to, or should, or must control regulation on that subject. To find implied preemption at the federal level, for example, courts must determine whether Congress has occupied the field in an area of law that the state is attempting to regulate, or whether a state or local law either directly conflicts with federal law or might frustrate the purposes of that law. To accomplish this, courts often try to determine either Congress's intent or the state legislator's intent in passing a particular law. Also, to determine whether a state law preempts local action, a court will determine what local powers have been granted or revoked. A court's implied preemption analysis may depend on whether a municipality is a home rule or statutory city or county, which my colleague Mike Freiberg will discuss later on. Here's an example of implied preemption from Wisconsin. Wisconsin statute section 139.43 states that Wisconsin will regulate the cigarette taxes. And so it's not clear as to how broad this is, but a clear reading of the statute might cause one to believe that it only applies to cigarette taxes. After this statute was passed, the city of Fond du Lac, Wisconsin, passed a law regulating the self-service displays of cigarettes in retail stores. The regulation was challenged in court by U.S. Oil, claiming that the city was preempted from passing any point of sale policy, including the regulation of self-service displays under Wisconsin statute section 139.43. The court heard the arguments and found that the Wisconsin state legislature meant or intended to declare all aspects of tobacco distribution a matter of state concern, and that municipalities are thus preempted from regulating self-service access to cigarettes. So, is preemption important? Absolutely yes. When it comes to public health, preemption really is that important. Here are a few quotes on the screen about the importance of state and local public health power. Preemption results in weaker public health standards. This matters because local control of health and public health issues has numerous benefits that are lost when local power is preempted. As Howard Koh, Assistant Secretary for Health in the U.S. Department of Health and Human Services, has said, all public health is local. It's got to start and be sustained at the local level. Local control provides for greater accountability because local legislators interact with their constituents on a daily basis, and they may even be neighbors. Local policymakers can craft laws addressing the unique needs of their specific communities, which fosters innovation and allows for diverse communities to adopt appropriate protections for themselves, rather than accept a one-size-fits-all top-down standard. Local control and grassroots movement building can also empower the public health field to pursue fundamental policy change. Many would agree that the tobacco industry was actually the first to use preemption as a tactic to prevent local governments from enacting public health regulations. Internal tobacco industry documents reveal that removing local government's ability to protect indoor air quality was a #1 priority of the tobacco industry in the 1990s. The idea being that it's easier for them to undermine one big fight in the federal or state legislature than 50 state campaigns and, say, 100 local campaigns throughout a state. As Walker Merriman, spokesman for the Tobacco Institute, stated, with 95,000 local units of government, it's hard to keep track of them all. Having to fight a battle on many fronts is, as Merriman put it, like being pecked to death by ducks. Remember the equity slide I showed you at the beginning of the webinar? The issue of preemption and local control has always been about equity. Health equity requires local control. For example, look at the work being done to regulate the sale of menthol tobacco products in cities across the United States, including San Francisco and Minneapolis. Menthol tobacco products have been targeted to specific communities like the African American community by the tobacco industry for quite some time. Local work is looking to address that targeting from that industry. The retention of local control is a key issue for addressing health equity and finding tailored policy solutions that best serve a community's needs. Here are some statements from public health groups regarding preemption. As you can see, preemption is a bottom line that they will not cross. Often, preemption language is introduced very late in the legislative process, even after a public health policy was supported and worked up without preemption language. This means that support must quickly change their position to oppose when they have been working to pass a regulation. The idea here is that a regulation with preemptive language is worse than no regulation at all. To ensure that a policy stops in its tracks once preemption is on the table, all major stakeholders should understand preemption and agree on a firm position on preemption before entering the legislative process. Okay, so you should expect in the public health field that preemption is going to become a part of public health legislation at the federal or state level, even if it's not part of the original bill. Many industries and their lobbies are looking to start local action that does not align with their special interests. Sorry, I skipped ahead. Where should you look for preemptive language? Well, not just in the public health field that you're working in. More industries are looking to stop local action, and it doesn't just stop with, tobacco control or healthy eating, whatever you're working in. Some examples of other areas in which preemptive laws have been passed include anti-discrimination, as you've seen in North Carolina, climate change, minimum wages, food labeling, paid sick leave, and plastic bags. It's important to look for preemption language in regulation that is not necessarily related to the public health field that you may work in. Take fracking, for example. Preemption language used in fracking regulations affects a local community's right to pass or amend zoning and land use laws. Some states are forcing local governments to allow energy companies to drill natural gas by preventing them from passing local zoning and land use regulation that would prohibit such activity. Not only is this hazardous to public health and specifically the interests of clean drinking water, but also, in effect, prohibits local governments from passing other local zoning and land use regulation related to other areas of public health, like tobacco advertisement regulation. In some cases, a law that preempts local regulation dies and is added to an unrelated bill. So look there too. There's evidence that strategic use of preemption to stop local action is connected to corporate special interest groups like ALEC, the American Legislative Executive Council. Here's language to watch for that should raise a red flag. The only way to guarantee that a federal or state law will not preempt state or local laws is to include a non-preemption clause, also known as a saving clause. For example, a federal law might state, nothing in this law preempts more restrictive state or local regulation or requirements. All proposed federal or state legislation should include a well-drafted saving clause that preserves the authority of lower-level governments to adopt stronger health protections. Then ensure that this anti-preemption language is not removed or weakened later on. All this to say is that preemption laws are very traditionally difficult to repeal. So it's important to prevent preemption because repealing is difficult. While there may be an interest in repealing preemption through a statute or other measure, like a ballot initiative, it's hard to do the workup in order to make that happen. So here's just a brief example of federal preemption, which covers all of the concepts that we covered. The Family Smoking Prevention Tobacco Control Act, signed by President Obama in 2009, expressly preempts state and local governments from regulating tobacco product standards, pre-market review, manufacturing practices, labeling, and product registration. Those powers are reserved to the federal government. However, the Tobacco Control Act also includes language explicitly stating that the act does not preempt state and local communities from enacting more stringent tobacco sales and distribution restrictions, youth possession restrictions, use restrictions like smoke-free laws, fire and safety standards for products, or taxes on tobacco products. The Tobacco Control Act thus sets a minimum standard in regulating some aspects of tobacco products, but allows states and localities to adopt more restrictive tobacco control regulation in these areas. Okay, so we've done an overview of government powers, talked about federal government, and discussed preemption and why it's important to understand that. If you're working on a policy campaign, it's important to understand concepts like preemption and federalism. Many of the people we work with advocate for policy change at the local government level, so it's important to understand the limitations of those local government powers. Mike will now take the reign and begin our discussion of local government, law, and policy.
Thank you, Natasha, and we'll just take a second here just to get set up here. So I'm going to start by talking about local government and the different types of local government out there, and then I'm just going to give some sort of practical advice on policy drafting before handing it over to Molly Moilanen from ClearWay, Minnesota, who will talk in greater detail about the logistics of working with a coalition on a policy drafting campaign. There's a lot that goes into that beyond these, drier legal topics, which Natasha and I as attorneys think is totally fascinating. But Molly has some real interesting and very relevant experience on the ground doing it. So local government, Natasha mentioned some of the elements set out in the United States Constitution, setting out the distribution of powers between the states and the federal government. But nowhere in the United States Constitution does it mention the authority of local governments. It doesn't really say anything about local government at all. It just generally talks about state authority. And when the United States Constitution talks about state authority, there's a general assumption it's also talking about local government authority by extension. Local government is generally viewed as the level of government that's closest to the people and handles issues that affect them every day. I spent about 9 years on the city council, and we dealt with, pothole filling and sewer infrastructure and police protection. That's a lot more concrete to people than some of the stuff that is handled at the federal or even at the state level. And, when the Constitution was written, really, there probably wasn't that much thought that went into local government at all, because it was such a different country at the time. So much is different now than when the Constitution was written, and what citizens need and expect from government is much different. Local governments, are important, more important now than they were at the time, to address the higher population, the fact that there are more laws and such complex systems out there. In 1790, around the time the Constitution was drafted, the largest city in the United States was Philadelphia, with a population of only 40,000 people, and the population of the entire country was 4 million people. We have cities that are bigger now than the population of the entire country at the time. Now, this is a quote from the League of Minnesota Cities, but I think it's probably true in all states. Local governments have gone from being simple service centers for a mostly agricultural society to complex governments that deal with industry and commerce and recreation. The things they're expected to do now are very different from around the time, that city government started being incorporated. Local governments, are created through state constitutions and state laws, similar to the way the United States Constitution sets out the authority for state governments. State constitutions usually oftentimes will set out the state constitutions, or state statutes, state laws will set out the authority of local governments in that state. The state laws often, provide the authority for those governments and sometimes restrict it. And there can be different types of local governments that vary in form and function, even within the same state. And the authority states give to local governments often takes one of two forms. So some of the states that are out there are known as Dillon's Rule states. You may have heard of the term Dillon's Rule. Now, John Forrest Dillon was an American jurist who served on both courts in Iowa, federal and state courts. He authored a very influential treatise on the power of states over municipal governments, and Dillon's Rule itself was expressed in a 1968 decision of the Iowa Supreme Court. And it says essentially that local governments are creatures of the state. It says that the power of cities and counties and other municipal governments, they don't have any unless it's specifically granted by a state law or a state constitution. If it's unclear what the authority of a state government is, any dispute over that must be resolved against the local government unit. So Dillon's Rule has a pretty restrictive view of the authority of local governments. Now, I mean, in practice now, you'll find that most states aren't pure Dillon's Rule states or home rule states. They might take elements of both even, or there might be some limitation or some provisions in the state constitution in Dillon's Rule states that specifically grant some authority to local units of government. But this is sort of the way that many of them were created, and there are still effects of Dillon's Rule in many of the states that follow it. The other way a state might grant authority to a local government is through what's known as home rule. Now, home rule really emphasizes the concept of local control. It provides for local self-government while retaining state sovereignty. Generally, sort of the default position is that local governments have the authority to regulate in a certain area if it's a home rule state, unless the state legislature or the state constitution explicitly restricts it in some way. So citizens manage their own affairs locally with minimal interference from the state. Home rule is often set up through what's known as a charter that's kind of like a constitution that the city has itself. And so there'll be authority, usually in a state statute for cities to create a charter. They often have to have a charter commission about what they can do, but that's how it works. And the authority of local governments often includes the ability to regulate public health. Now, Jacobson versus Massachusetts is the classic case that sets out the authority of state and local governments to regulate public health through what's known as their police power. That case involved a city ordinance which required everybody to be vaccinated against smallpox, unless the doctor verifies that they are unfit subjects for vaccination. Mr. Jacobson refused to be vaccinated and he was cited. This was a city ordinance from the city of Cambridge, Massachusetts, that required him to be vaccinated or to essentially be violating the law. And the United States Supreme Court upheld the authority of the city of Cambridge to adopt the ordinance. It used very strong language saying that the police power of a state must be held to embrace such reasonable regulations established directly by legislative enactment as will protect the public health and the public safety. So this is, this states very firmly that states and by extension local governments have public health authority. And it's there in a United States Supreme Court decision. This case dealt with vaccination, but if you're working in the tobacco control context, like the three of us who are speaking here do, or even in a healthy eating or active living type situation, this is a strong statement by the United States Supreme Court that supports the authority of state and local governments to adopt these regulations. The public health authority of states exists in the different branches of state and even local governments. Particularly if you're working in a much larger city, you might even see some sort of administrative agency that might be there. But at least at the state level, in the state legislative branch, the state legislature and other state legislative bodies create policies and law. They distribute funds. The legislative authority of cities is often enacted through ordinances. The executive branch would be the governor in most states, as well as the state agencies that report to the governor. Those can issue rules and regulations based on the authority delegated by the state legislature through statutes. At the city level, you often have a mayor. There might be a local public health department that functions similarly. And then at the state level, you'll have a judicial branch that can resolve disputes and interpret laws. And there are many different levels of local government. And these are the ones I'm sure many of you have worked with. Counties are often the administrative arms of the state, and they're created to carry out state mandates. Cities generally provide governmental services in areas that are intentionally developed for residential, commercial, industrial, and governmental purposes. Obviously, there's a greater need for government services when people are living in close proximity to each other. Townships generally are governed by an elected board of trustees and often provide governmental services in areas used or developed for agricultural or open space or rural residential areas. They often have broad authority, but they may not always exercise it. At least here in Minnesota, a township would have the authority to create a park, but most of them don't. If you don't have that many people, and most of the people you do have each have more than 1 acre of land, there probably isn't a huge need for parks for people's children. Special purpose districts would be things like school districts, hospital districts, or regional governments. The US Census actually defines these, and these are local entities authorized by state law to provide only one or a limited number of designated functions and with sufficient administrative and fiscal autonomy to qualify as separate governments, known by a variety of titles, including districts, authorities, boards, and commissions. They can vary widely for what they do. They might only have a function of street lighting, or they could be a large port authority that has a large staff and a project portfolio. School districts are one we often think about when we think of special purpose districts. They're created usually by state legislatures, and their purpose is to provide public education. You may also see soil and water conservation districts, regional development commissions, lake improvement districts, watershed districts. Now most of these levels of government have elected officials in charge, but if you're looking at a special purpose district, it might be an appointed official as well. And their job's to educate themselves on the issues, participate in meetings, vote, serve as a liaison between the entity and its residents or other constituents like businesses. So we've talked about how government authority gets divided at different levels. We focused a bit on local government. I just want to give you some practical suggestions on what kind of law you'd want to work with. People sometimes ask us, whether it's better to work to get an ordinance drafted or a resolution or a policy. Now, all of these terms fall under the umbrella term of law. Here's kind of a fancy definition of law of the sort you might find in Black's Law Dictionary. They call it the regime that orders human activities and relations through systematic application of the force of politically organized society or through social pressure backed by force in such a society. But we often think of law just as an ordinance or statute. So another term we often use is policy. And this is kind of another fancy definition from Black's Law Dictionary. It's just a standard course of action that has been officially established by an organization, business, political party, etc. And it says, see public policy. And that's more a policy passed by a government body of some sort. This is maybe a more straightforward and functional definition of policy that you can use. It's we often think of it as something in writing. So any written plan or course of action designed to influence and determine decisions. It can be like this path you see in the picture here. It's part of the environment guiding us in ways that we don't even realize with our conscious thoughts. So, and just to kind of get back to what I was talking about, a lot of times, especially at the local government, people aren't sure if it's better to work on a policy or an ordinance or a resolution. And, it often kind of depends on the level of government you're working with and how that level of government defines these terms. What we may often think of as a resolution may actually have the force of law and be something closer to what we often think of as an ordinance. But, as a general rule, we may think of local governments tend to think of policies as something that's not actually passed by the legislative body. It's more a written guideline for an administrative agency to implement just in the property that it controls itself, whereas an ordinance might be something that is passed by a legislative body that has the force of law that can be enforced by either the police or by other enforcement agencies at the local government. And we often think of a resolution as something where a government body just sort of states its view on what it thinks should be done or what it thinks another level of government should be done. But it's not often something with the force of law that can be enforced against private citizens. But again, all those are just sort of general definitions, and you need to know how they're used in the community that you're working with before engaging on a policy campaign on it and determining what the best approach is. You may want to speak to a city or county attorney, for example, to get that question. So, what makes a policy effective? Generally it's something that addresses a proven issue. I mean, in the public health field, we often follow the precautionary principle where, if we think something's harmful, then it's better to err on the side of caution and adopt a policy that will address what's potentially a dangerous issue. But it's, the most effective ones, there is evidence behind them that we can follow. An effective law or policy is one that's easy for people to understand and easy for them to follow. A lot of times, a smoke-free policy, for example, we say it's self-enforcing just because if people know smoking is prohibited in indoor areas, they're more likely to do it. And you might even have just a citizen telling another citizen not to smoke and not even need to resort to a law enforcement type approach because they know what's expected of them. And that's the third bullet here, is that it's easy to enforce. It should accomplish its goals. So if you have if you're trying to work on a policy to prohibit smoking in multi-unit housing, and you actually get a policy passed, but then after a few months of having it in place, there's still smoking going on in a multi-unit housing policy, then that's not a policy that is actually accomplishing its goals. You'll want to work on it to make sure that those sorts of issues can get addressed. And it's supposed to be something. It should also be something that's within the authority of the government at the level you're working at to adopt. And Natasha talked about preemption, so you'll want to make sure you're not working at a level of government where there is preemption of some sort. Several things you'll want to consider before working on a policy are both legal considerations and practical considerations. So, I already mentioned the issue of general authority. You'll want to know, if you're working with the city government, whether you're working in a Dillon's rule jurisdiction or a home rule jurisdiction, or one that's both, and what sort of principles limit the authority of a local government to work on at the beginning. And another one of those could be preemption. There could be a preemptive law. You'll want to know about that. And if it's a preemptive law that affects the issue you're working on, or if there's some creative way you can look at it where you can pass a similar law that gets at the goals you're working on, but does it in a way that doesn't conflict with a preemption clause. I think that's something we could help with too. You'll want to know if there's any sort of constitutional issues that you should be concerned about. So if you're working on a smoke-free law and somebody proposes an exemption for private clubs or casinos or so forth, you might see some of the places that are impacted by the smoke-free law challenge those exemptions on equal protection grounds. Now, usually those sorts of exemptions will be upheld by courts, but you do want to know, you do want to go into it with eyes open and know that there is a possibility of legislation, or of litigation rather, potentially on constitutional grounds if you do include lots of exemptions. You'll want to know the practical issues like enforcement, the capacity of the unit of government you're working with to handle enforcement, and the costs of implementation of the policy. Do you need to do compliance checks? How much will that cost? And the possibility of a legal challenge to it, and what the potential costs of a defense of it might do. An important aspect in any public health law is evaluation. You'll want to have a method to evaluate the effectiveness of your law, and just evaluate it maybe 6 months, a year out, or evaluate it at regular intervals to see if there are ways it can be strengthened or whether it's working really well. And you'll want to know if it has any unintended consequences, like were there any loopholes in the law that weren't anticipated at the time the law was considered that are leading to essentially the law being circumvented and the goals of the law not being fully realized. There are several things that should go into any law that you're working on. Some of these slides, I could probably spend an hour talking about and, bringing in lots of different examples, but this is just intended to be sort of a 30,000-foot overview. But if you have any more specific questions, you're welcome to ask them as part of this webinar or to contact Natasha or me just for legal technical assistance. But some of the essential elements of any law or policy, they should have a findings section. If you're working on a smoke-free law, for example, it could say what the smoking rates are in the county you're working in. So for example, if the smoking rate in your county is 30%, but the smoking rate statewide is only 18%, you can say, smoking is particularly a problem in our county, and the smoking rate is 12% higher than it is statewide. And then the purpose statement would say something like, therefore, the purpose of this law is to protect residents from the known harmful effects of secondhand smoke. Now, the findings and the purpose statement often sort of work together, and they can help courts actually interpret other provisions of the law if any of them are ambiguous. So if the law, that the law applies to area B, but not area C, and then there's an area D, and you don't know whether, and it's a little unclear whether or not the law applies to that, a court might look to the findings and the purpose statement and then say, well, since the purpose of the law is to protect people from secondhand smoke, we should give the law its broadest reading and apply it to area D as well. So that's just part of the value of having a strong findings and purpose section. The definitions section of the law is extremely important because it says basically what the law regulates and where it applies. And what it covers. So if you're working on a smoke-free law, having a strong definition for public place or place of employment or smoking even can be really important. There are lots of new products out there, and a lot of smoke-free laws were written in maybe 20 years ago before we've seen things like e-cigarettes or some of the even newer heat not burn products. So and if people are still able to use those products in public places, that could undermine the effectiveness of some of those laws. So having a strong definitions section that covers some potentially unforeseen circumstances is really important. Okay. And the restrictions or requirements section of a law is sort of the heart of it. It says what activity is restricted or what people are required to do. That's really actually probably the most important section of it. There, a lot of times you'll need to discuss exemptions, and Molly's going to talk a little bit about that, I know too. Generally, you'll want to limit it because they undermine the effectiveness of the law that you're working on. But it will say where the law doesn't apply. If there are areas where the law would otherwise apply, an exemption section would say, well, it doesn't apply here. You'll want to set out strong implementation and enforcement provisions so that people understand what's expected of them. Implementation could include educating the public about the law, and then enforcement is making sure it's in effect. If you're working on a youth access ordinance for tobacco products, setting up the process for compliance checks is an important aspect of enforcement. Severability clause, it's kind of a legal term, but it says basically if one provision of a law is struck down by a court on some constitutional basis, the rest of the law will stay in effect. And it's just a generally good idea on a legislative drafting principle to include a severability clause. So these are just some drafting tips for working on law or policy. You'll want to be clear and specific. You'll want to use definitions appropriately, and generally avoid assumptions. So you don't, if you think people know what smoking means, that might be appropriate for a less formal policy that just applies, for example, to one school. But if you're working on an ordinance or a statute that will actually be enforced by law and could potentially get challenged in court, you'll want to make all of your meanings and intentions clear. So that does mean some definitions can get long, and sometimes the second goal here of being concise can be hard to meet. But if there are unnecessary words in a definition or in an ordinance, you'll want to take those out, and you'll want to use terms consistently. So even if you're working on a school level policy, you probably wouldn't want to use the terms e-cigarette in one place and then vape pen in another place, you can have problems if things end up being inconsistent. And we can help with ensuring, reviewing policies if you have any questions about something like this. You'll want to avoid unnecessary exemptions, which, as I mentioned, could undermine the effectiveness of laws, make enforcement harder, and can potentially encourage lawsuits. You'll want to be practical and consider the ability to achieve the purpose. So you'll want to be looking at factors like costs or effective dates of the policy. If you're working on a smoke-free policy, you may not want it to take effect at midnight on January 1st, even though that does seem like it might otherwise be a logical time for a policy to take effect. You want to think about, okay, what are people going to be doing at midnight on the night of December 31st? They might be at a party. So having it take effect, in the morning when business is open might make more sense. And you want to do your homework, and that includes a bunch of different aspects: identifying stakeholders, which I'll talk a little bit about on the next slide, seeking legal technical assistance from us, as well as technical assistance in other areas like media or coalition building, and Molly will talk a little bit about that, and review example policies. You don't want to rely on them too closely, just because what works in one jurisdiction may not be a good fit for your own jurisdiction. But model policies can be a good starting point, and we do have a few sample policies that you can consider on our website. So these are just some of the people you may want to consider contacting before you embark on a policy campaign. And that includes both supporters of the policy you're working on, but also potential opponents. Working with opponents early can help you to identify some of the potential arguments that will be raised against the policy you're working on. So supporters might include government staff. They're the ones who have to enforce it. So they're really important to get on board early, just so they don't raise any objections that can carry a lot of weight with the elected officials. The government body will probably have a lawyer that you're working with. That's an important person to contact. Mentioned enforcement agencies, advocates, coalitions, health professionals that are out there. There may be people already working on this issue, as well as community-based organizations. And the potential opponents might include business owners or interested industries. And when you're working with them, you'll want to be prepared to counter typical arguments like lost profits or constitutional issues. So that's kind of wraps up the comments that I have. And knowing who to work with is actually the perfect time to transition to Molly Moilanen, who will give some practical tips from her years of experience working on policy change at different levels.
Thanks, Mike and Natasha. It has been an excellent refresher for me so far. Really appreciate the opportunity to be a part of this presentation. As Mike and Natasha said, I'm Molly Moilanen, Director of Public Affairs at ClearWay, Minnesota. A little bit about ClearWay. We're an independent nonprofit organization that has been established to eliminate the harm that tobacco causes the people of Minnesota. And our work encompasses cessation services, public policy activities, research, media campaigns, and community outreach. We were created back in 1998 and entrusted with overseeing 3% of Minnesota's tobacco settlement funds, and we have a lifespan for 25 years. We will sunset by January 1st of 2023. I also co-chair our statewide tobacco control coalition called Minnesotans for a Smoke-Free Generation. Our coalition consists of over 50 organizations that share a common goal of reducing youth tobacco use. Our coalition includes organizations like the Voluntaries, American Heart Association, the Lung Association, the American Cancer Society, Cancer Action Network, doctors groups like the Minnesota Medical Association, Twin City Medical Society, the Pediatrics, the Family Docs, etc. We also include healthcare institutions like Health Partners, Alina, and the Mayo Clinic, as well as groups that serve priority populations and other vulnerable populations. We've been focused recently on trying to recruit new, less traditional partners like local chambers of commerce and local businesses. Our coalition has 4 major policy priorities. The first 2 are long-time best practices. They are evidence-based strategies held up by the CDC. keeping tobacco prices high, and fully funding tobacco prevention and cessation initiatives. The second two are gaining momentum across the country as promising practices with an emerging evidence base, raising the age of tobacco to 21 and restricting the sale of flavored tobacco products, including menthol cigarettes. I work in partnership with other coalition members to advance these policy priorities as well as to protect past legislative gains. Unfortunately, at the state level, we're playing a lot of defense these days. For my part today, I'm going to focus on my top 10 list for advancing your policy priorities. All of my examples today are from my experience working on tobacco control policy campaigns that I've been involved with over the past 10 years in Minnesota. And I want to acknowledge up front that these wins were because of huge contributions from scores of people, too many to name, and I played a role, yes, but I am no way claiming exclusive credit. All right, as a lead into my first tip, I want to talk for a minute about the social norm change strategy that many of us employ to improve health outcomes for everyone. The social norm change strategy is illustrated here by the social issue cycle, which I stole from the California Tobacco Control Program. It works by moving an organization, a community, or the general public along a cyclical continuum that may begin with apathy for an issue. Through education and outreach, awareness is raised, which results in a concern for an issue and shifts in attitudes. These attitudinal changes create a social expectation that action will be taken to resolve the issue. In turn, the social expectation for action provides that political will necessary to support policy, environment, or system-led changes, which result in a new social norm. As the new social norm is broadly adopted, there is an expectation that people, communities, and organizations will conform to the new social norm, resulting in contentment. So my first tip is to be mindful of that cycle. While it is easy for us to focus on the action and the legislative steps, we actually spend more time in the other stops along the way. So a key question is, where are you on the cyclical continuum, and how can you create urgency to move to action faster? As a limited life organization, this is a critical question that we at ClearWay Minnesota ask all the time. We don't have time to wait for our issues to move organically. Every day we are challenging ourselves to think about how we can move the needle faster. One tool we use to know when an issue is ripe for action is tracking public opinion over time. This is a chart that shows how public opinions towards statewide smoke-free laws changed over time in Minnesota. One benchmark we use for ripeness, is when strong support, that's in the dark green, outweighs total opposition, that's the dark red plus the pink. In the case of a statewide smoke-free law, we hit the tipping point for action around 2006 and passed our bill in 2007. This chart also shows how the social issue cycle plays out in public opinion. Early on, you see that we have a foundation of support. About half the public believes there's a problem. Over time, there's a growing sense that more should be done. Again, over short, intense times where we used a lot of advocacy and outreach, we're showing up our strong base, moving our undecideds, and increasing in intensity. After action and ultimately implementation, we see another shift, and smoke-free workplaces become the norm, widely accepted and supported by the vast majority of the public. Moving on to my tip number 2, make a plan. We could teach an entire semester on strategic planning, but let me boil it down into 2 slides. My boss at ClearWay Minnesota is a gifted strategic planner, and her commitment to sound strategic planning has rubbed off on me. First, the purpose of planning is to create a blueprint to accomplish goals. It should answer questions like, where are we heading? What roads will we take to get there? What are our strategic priorities? And who will do the work? Goal setting is really important up front. Well, it's always important to start with the long view. Short and middle distance goals are important building blocks. The planning process should create buy-in and commitment from those involved. So make sure you have the right people involved from the beginning around the table. Planning helps people concentrate their efforts on the most important jobs rather than wasting time on the lesser important work. Planning helps control costs, it eliminates unproductive efforts, and it maximizes efficiency. In the end, a successful plan should be flexible and help management in adjusting according to the changes in the environment. It should be used to foster accountability, to create teamwork. Team members should know their role and be held accountable to accomplish their areas of their plan and they're responsible for. All aspects of operations and implementation should consider how any given project or program or campaign supports the organizational plan. Finally, good planning should take a reasonable amount of time and resources. As an example, when our coalition started to plan for a statewide tobacco tax increase, we knew it was going to be a long road. We started a planning process in 2009. As a coalition, we developed short-term goals and outlined strategies and tactics that would help nudge the ball forward until our window of opportunity opened. Up until 2012, we had divided government, and the Republican majority was committed to a no new taxes approach. With that in mind, in 2010, we set a short-term goal. We worked with Democrats and Republicans to pass the Tobacco Modernization and Compliance Act, which updated our definitions for tobacco products. This was a valuable opportunity to work on a less controversial bill with leaders from both parties. Now in 2011, our interim goal was to find moderate Republicans to introduce a tobacco tax increase. We focused a lot of energy and efforts on the strategy and it paid off. With a Republican chief author during a session where Republicans held the majority, we were a legitimate part of the debate around tobacco tax policy. Now, our bill didn't go anywhere, but it gave us a platform to keep our messages in the mix longer. When the Democrats took back the House and Senate in 2012, we were so ready. Our planning had paid off. Our short-term goals were some of the stepping stones we needed to eventually help pass the largest tobacco tax increase in our state's history. My third tip is all about coalitions. And I know working with coalitions can be challenging, but I truly love it. And I know firsthand how good coalitions can really make a difference in your ability to pass bold policies. That said, there are many types of coalitions and many types of coalition leadership. And at the front end, you'll want to be really intentional about what type of coalition you're going to have and what leadership style is most appropriate. In my experience working on statewide policies, our coalitions have been more formal with an official sign-up process. We typically have committees chaired by active members, and we have a mechanism for making crucial decisions in a timely fashion. While the coalition chairs usually bring recommendations forward, we work to build consensus and decide on our deal breakers together. In contrast, other coalitions I've been a part of have used a more servant leadership approach. I think the co-chairs of the coalition that pushed for a menthol tobacco restriction in Minneapolis this year employed this leadership approach, which really allowed for a more authentic community and youth-driven process. Moving on, my fourth tip is champions are gold. And when I'm talking about champions, I'm talking specifically about the elected officials who agree to take on and own your issues as their own. Identifying champions and building trusting relationships with them takes time, but it pays off. As you are deciding who to approach to be your champion, be strategic. There are obvious choices, but think about some of the hidden gems, the less obvious picks who can get you over the hurdles and move your issue further, faster. In Minnesota, we always like to have, yes, Republicans and Democrats, but we also think about wanting our champions to be from both the metro and the rural parts of our states. While our bills almost always go through health committees, our bills also go through committees like Commerce and Judiciary. So having champions who sit on those committees can be even more helpful than having health advocates. And I'll end this tip by saying, make sure to thank them. Come up with creative, fun, public ways to thank them. There are award ceremonies, letters to the editor in local papers, and of course, nothing beats a traditional handwritten note. Tip 5 is all about your message, and even more importantly, in my opinion, your messengers. Everyone knows the importance of having a simple, cogent message that resonates and moves your key audiences. But getting partners and champions to use them is a different story. We've tried a lot of approaches: one-on-one practice sessions, pop-up practice sessions at our coalition meetings, message boot camps for our regular spokespeople. I'm always interested in different ways groups instill message discipline. So send me your tricks after we're done and I will appreciate that. So messages and message discipline is really important, but having a deep bench of articulate, authentic spokespeople representing all different perspectives is equally as important. This point really goes hand in glove with the importance of having a robust, engaged coalition of partners and people who share ownership of the project. One example that I want to highlight was our ability to move Governor Dayton, our governor, on increasing Minnesota's tobacco tax. Initially, he was unsupportive. He was concerned that the tax was regressive. He didn't want to impose a burden on low-income Minnesotans, which were very legitimate concerns. But over our years of planning and practice, we had strong evidence-based messages that addressed his concerns. However, what moved him in the end was hearing these arguments and concerns and the messages from diverse leaders and youth advocates who are deeply involved and invested in the campaign. Now I'm happy to report that Governor Dayton is a strong ally on keeping tobacco prices high to prevent youth smoking and to prevent the tobacco industry from padding their profits. My sixth tip is to know the rules better than your opponents, and you will control the game. Rules are impartial. When you are in the minority or you're playing defense, knowing the rules better than your opponents can make a huge difference in the outcome. Natasha and Mike went through the rules at the different levels, and just to restate the obvious, the rules are different at different levels of government, but rules are also different between legislative bodies. They're also different at the local level. Every council I work with has a different rules or the different interpretation of them. So you can't assume your success in one city will follow the same path in another. Now, to go one level deeper, knowing the committee process, for example, is really important. It's helpful to know if you need a majority vote to get out of a committee or if it can be passed along with no recommendation. Another example, knowing the different rules for policy bills versus finance bills can be really important too. If your bill is moving through the process on its own, then you have to make sure you have the vote each step of the way and on each amendment. For example, as Mike talked about smoke-free policies, here in Minnesota, our bill was called the Freedom to Breathe Act. That bill had to go through numerous committees. And so each committee stop, we had to have a solid vote count. We had to anticipate amendments and again, make sure we had the votes to vote down any bad amendments and get the ones on that we wanted. In contrast, our tobacco tax bill was only heard in one committee, taxes, and then it was folded into an omnibus bill that wasn't finalized until the last minute, the last night of the session as a part of a global deal. So we never even needed a clean vote count on that. And these are both big public health wins with very separate, different paths and different rules that govern their process. Now the opposition, I'll tell you, knows the rules really, really well, and they know how to use them to delay. So don't let them outsmart you or your champions. So that brings me to tip number 7, study your opposition. In tobacco control, because of the Minnesota settlement, we have access to the tobacco industry documents, which are a gold mine of information about what the industry knows, how they manipulate their products, and target various populations. There's a mountain of peer-reviewed research articles studying the industry documents, so that's always a good place to start. Today, unfortunately, they're not as overt as they were before their secret documents were made public, but they still share a lot about their concerns and the tactics in their industry publications. So that's where we like to look and track and share along the way. Here's an example from Tom Bryant, a longtime tobacco industry lobbyist. In a recent article in an industry publication, he reinforces the industry's longstanding sentiments that local ordinances are the greatest threat to the tobacco industry. He goes on to name the states where most of the activity is focused, including Minnesota, and he names the local policy restrictions that they are most concerned with, which again helps affirm that we are focused on the right policies: flavor restrictions, price policies, and tobacco 21. In addition to the usual suspects, here are some recent examples of opposition tactics that we have been gathering and analyzing. The first logo is from a group branded Tobacco Harm Reduction for Life. Now, they use very similar messages to our side, and it gets confusing to elected officials who don't work on tobacco prevention every day. Unfortunately, this is a group of e-cigarette retailers and manufacturers and some users as well. So you can see where that can be complicated. This is very common that opposition groups take over your messaging and try to confuse the issue. Now, the picture of the back of the t-shirt is from the cover of an industry magazine published just in the last few weeks. While Big Tobacco is funding the opposition efforts, this t-shirt illustrates their ability to engage local retailers as key messengers and as more sympathetic key messengers. The Facebook ad on the lower left is from Citizens for Tobacco Rights, which is funded by Altria, maker of Marlboros. If you live in St. Paul, Minnesota, and you're on Facebook, you cannot miss this in your feed right now. It is everywhere. Finally, the opposition is leveraging community discussions about race and inequality to build support against tobacco prevention measures. This strategy is illustrated here in the Enough is Enough Twitter feed. The tweet reads, "Minnesota continues to struggle with inequality. Let's not add tobacco ban to the growing list of concerns. Let's focus on what matters." To continue this thread, we see the tobacco industry perpetuating concerns around racial tension by paying for events at Black churches and engaging well-known leaders. Reynolds America, maker of Camels and Cools, worked hard to stop a local ordinance restricting menthol tobacco sales in Minnesota. Again, having an engaged coalition of African-American leaders leading the policy campaign really helped minimize the potential impact that an event like this could have had. The big takeaway here is when this comes to your community, make sure you're sharing opposition tactics with your coalition members and sharing with your counterparts around the county or the country, whatever the case may be. Number 8, learn at the local level. In states that don't have preemption, local efforts are so helpful for learning. You get a chance to test your organization abilities. You get to refine your messages and learn what the opposition is up to. Local advocates get a taste of campaigns and hopefully what a win feels like. And then they want to help on statewide efforts as well. Local wins can lead to statewide success. Building momentum, refining your game at the local level can get you to the tipping point needed to pass the statewide policy, if that is indeed your end goal. As these articles show, in Minnesota, we are working hard at the local level to build momentum for an eventual statewide Tobacco 21 law. We have had some success, but not everywhere. We're learning from our wins and losses and trying to be smart, strategic, and coordinated about where we put our local energies. Now, caution before compromise. You always hear that in politics, compromise is the name of the game, but I want to push back on that a bit. While it has its place for sure, you need to be wary of compromises and be really clear about what you're going to gain with that compromise and what you're going to lose. If you're going to gain a key vote, maybe it's worth it, but you really have to ask that question. As your partners will also be thankful if you think ahead about what precedents are you setting with that compromise. That said, I want to fully realize that, it's a political dynamic process. And once you hand your bill or your legislation or your idea over to your champion, you lose control. So what you can do is set up the best parameters you can with your champions. And as they have to negotiate in the final analysis, you may not be in the room. So in the end, we're going to lose some control, but to be clear up front with where your lines in the sand are with your champion is really important. Finally, tip number 10, after you win, you are not done. Sure, absolutely, take time to celebrate. Help with good implementation. Enforcement is critical. As Mike referred to, evaluation is key, so you can apply those learnings going forward. Then you want the ability to demonstrate your successes across the country and with your partners. Share that information. Take time to construct case studies, share your findings, and be a mentor to another community or another advocate looking to follow suit.
Thanks, Molly, for that valuable insight. It's so important to merge the legal, theoretical policy piece with the practical and strategic policy work. We know they both affect each other. So let's move on to the question and answer portion. Molly, this one's for you. What should an advocate or advocacy group do if different members, if they're a part of a coalition and there are different members in the coalition that have different or competing interests? And so, are there circumstances in which you might consider working with what you would otherwise label as an opponent?
In some cases, yes, that you have a shared interest with someone or an organization that you may have been on the other side with. That's why I think it's really always helpful not to burn bridges at any point and keep the door open. But that said, I think you don't want to fall into the trap of ever negotiating with the tobacco industry in our case. So I think there are cases where there might be some alignment on some issues. A lot of times there are tobacco industry interests on either side. And I like to step out of that and let the industry representatives fight with themselves and stay out of those fights if I can.
Great. Thanks, Molly. Okay. Question for both Mike and Molly. So the science on public health policy is always evolving. So can you, Mike, maybe talk about the importance of including broad language in policy to address these issues? And Molly, maybe talk about how an advocate might stay on top of that evolving science and working that into strategic planning?
Sure. Thank you for the question. Yeah, the science is definitely evolving on a lot of these issues. So, that could influence the policy decisions you may ultimately want to make. For example, when we did start focusing very heavily on Clean Indoor Air Act laws 15 or 10 years ago, they were clean indoor air laws, but, we've been seeing more science come over the last few years about the possible effects of smoking in outdoor areas, particularly areas where children congregate, like parks or playgrounds or swimming pools. So that's an area a lot of jurisdictions that have already adopted smoke-free clean indoor air laws are looking at considering. And or if they don't have one in place, they might consider adding it and just making it a general clean air law, whether it's indoor or certain outdoor areas as well. And the science can actually work that way too, as far as the products. I mean, the tobacco market is constantly evolving. 15 years ago, we didn't see any electronic cigarettes. So, drafting your ordinances in a way that anticipate what the tobacco industry might come up with in the future is also an important component of that. We're starting to see some products now that heat a tobacco product but don't actually burn it. So if you define smoking in a Clean Indoor Air Act as igniting or burning tobacco leaves, then it might not cover those products. So wording it and trying to anticipate what might come down the pike as far as these products go is also important. So you might want to consider drafting smoking and regulating smoking, but define it in a way that it would include heated products like e-cigarettes or these heat not burn products.
And Molly, I'd like to hear from you. And I just want to say to anyone that's on the webinar, if you have questions, post them in the chat box and we'll try to answer them before we end here today.
I think it's helpful to use the resources that are looking at the science regularly, and so really to tap into those and bring those resources to your coalition meetings, to your staff meetings, or however you engage. I think that we don't have to recreate the wheel. We don't have to be doing the primary review of all the research that's out there, because groups like, Public Health Legal Consortium and others keep track of this too. And so to really look to the experts and the national researchers who are on top of this to help us at the local level, at the state level, and kind of in the trenches, make sure that we are aligned with the latest science is really helpful.
Okay, we have a question about exemptions. Mike, are exemptions good or bad? Why or why not? And Molly, can you talk about using exemptions as a negotiation tool? Where do you draw the line, especially if you're working in a coalition? I don't know, which one of you want to take that one first?
It's hard to say conclusively that all exemptions are bad. I mean, there might be some circumstances where you might want to consider including one. Just to give you one example in the smoke-free context, there several Native American groups have sort of a ceremonial use of tobacco products that involves burning traditional tobacco products. And if you are working in a community that has that has a large Native American population, or you're working on a tribal, Natasha talked about tribal governments, they're sovereign entities. If you're working on a tribal ordinance, if you're an advocate working at the tribal level and a member of the tribe, you want to consider including an exemption for traditional Native American ceremonies. And I know there's an exemption in the Minnesota state law about that. So there are circumstances where where it might be where you might want to actually consider them. Generally speaking, though, if we talked about this, if you are going to exempt certain types of businesses, that undercuts both the public health justification for the law, and it can make enforcement more difficulty. There, oftentimes we will see certain establishments, they'll go to a lot of trouble to try to get around laws like this. They might actually try to rebrand themselves as something, a private club, for example, rather than a bar to take advantage of one of these exemptions. So it can make it harder to enforce. It can lead to enforcement problems, and it could potentially increase the possibility of litigation against it too, if there are some businesses that are treated one way, but other businesses that are treated a different way.
I agree with everything that Mike just said. I just wanted to add to that a couple thoughts about decision-making around exemptions. So when you're working in a coalition, that decision-making about who gets to make the call on that exemption is really important. And so I've seen a couple different models employed. One, you have a way to have an executive committee that's really on call to come together quickly to make the decision together. And sometimes it comes to a vote and having the majority win out. In other cases, you have to trust your leadership and know at the end of the day, you've empowered them to make decisions in a timely fashion so you can move the issue forward. And that means not everyone gets to say, yeah, I had a stake or I had a point in that decision, but you have a leader of your coalition who's really empowered to make the decision on behalf of the coalition.
Okay, thanks guys. We're gonna just take our last question here because we want to be respectful of everyone's time. So we've mentioned today local jurisdictions that are passing flavored tobacco regulations on the sale of flavored tobacco products, but what about state government regulation of flavored tobacco products? What are the potential barriers or what authority does state governments have to enact these flavored tobacco sales regulations? So maybe, I don't know, Molly, if you wanted to come at it from an advocacy standpoint, or Mike from a legal standpoint.
Sure, I can just talk a little bit about the legal aspect. So, when Congress, Natasha talked a little bit about the Tobacco Control Act, which Congress passed in 2009. That prohibits the sale of, or prohibits the manufacture, I suppose, of any cigarette that contains what it calls a characterizing flavor. So like candy flavor, fruit flavor, alcohol flavor. But it did exempt menthol from that as far as cigarettes are concerned. And it didn't apply to non-cigarette tobacco products like cigars or smokeless tobacco. So you'll still see menthol flavored cigarettes out there, and you'll still see non-cigarette tobacco products with a variety of flavors out there. So, I mean, I sort of feel like there was, that people felt like that was maybe, I'm kind of speculating here. I mean, every state is different and every state has different concerns, but at least initially, I think people felt maybe like that was working sufficiently. And it wasn't until the last couple of years that I know New York City and Providence, Rhode Island, both passed ordinances that restrict the sale of flavored non-cigarette tobacco products, but even there they exempted menthol, mint, and wintergreen flavors. And it's really not until the last year or two that you've seen more local units of government addressing this issue and beginning to incorporate menthol. And there's a really sound public health reasons to incorporate menthol into any of these sales restrictions at the state or local level. So, it's possible at this point, maybe there just hasn't been enough action at the local level, and hopefully in a year or two, we might start to see more state governments do this as more and more cities start stepping into this area. That's just kind of speculation though.
Okay, thanks, Mike. So great questions. And if you have more questions, you might find the answers in the publications and resources that we have on our website. So thank you so much for joining us for a quick refresher, passing laws at the federal, state, and local level. We hope you found this helpful, and thank you, Molly, for joining us today and providing some really helpful tips on policy work. You can contact us if you have any other questions or find our resources online at publichealthlawcenter.org. You can contact us at the email address on the screen, publichealthlawcenter@mitchellhamlin.edu. Please also follow us on Twitter and Facebook, in which we do release information when we publish a new resource. And that concludes the webinar for today. So we hope that you all have a wonderful rest of your day, and thank you for joining us.